Hello, everyone. Good afternoon, and welcome to this week's Business in 2021 webinar presentation. My name is Kathy Purdy, and I'm a marketing manager at Bond. I'd just like to go over two quick housekeeping items before we get started. Please enter your questions using the Q&A box located at the bottom of your screen, and our presenters will do their best to address those as time allows throughout the program. Once the webinar has ended, we would appreciate you taking a moment to complete the survey. Your comments and suggestions are important to our panelists and also provide us with topics for future presentations. It is now my pleasure to introduce today's moderator, Pete Jones.
Good afternoon, everyone. It's good to be back with you again hosting today. It's been a while. I think we've all got vaccine mandates on the brain. They've been coming fast and furious. We had some major developments at the end of last week on the federal level. So we thought we would devote most of today's webinar to the vaccine mandate issue. And I want to begin today by kind of setting the stage a little bit for you. Some initial thoughts on what it means to have a vaccine mandate. And then from there, we'll move to talking about some of the individual mandates, in particular on the federal level, including the OSHA developments and the CMS developments that we saw late last week. So first of all, just a few opening thoughts in terms of what it means to have a mandate. And I think depending upon what we're talking about, I think it's fair to ask the initial question of, are we talking about a vaccine mandate? Or are we talking about a testing mandate with a vaccination opt-out? And they're all sort of grouped under the same rubric of a mandate, but I think the impact is very different. To me, a vaccine mandate is you cannot continue to perform a certain function or access a certain venue or attend events unless you've been vaccinated. And typically there may be exemptions associated with that, but that is a mandate. When you have a test out option, in many ways, you could almost look at it like it's a testing mandate with the option to vaccinate to avoid the testing. And so I think those are important distinctions, and we will see that they play out differently depending upon which mandate we're talking about. Second question that I think is important here is who is doing the mandating? And we've now got federal mandates, at least 3 of them of note. We've got state mandates, in particular the healthcare workers mandate at the state level has received an awful lot of attention. We have local mandates, including a couple in New York City, and then there's always the option that the employer may mandate. And so really, what the rules are and what the potential legal challenges are, what the pitfalls are, will depend upon the nature of the mandating entity. The other thing that I think we have to think about whenever we're talking about a vaccine mandate is what are the potential exemptions. From the very beginning, we've been focused on the EEOC's guidelines. EEOC has said from the beginning that you need to consider medical exemptions and religious exemptions. There is the possibility, of course, that you might consider other exemptions as well. And we've seen a lot of energy around what's the necessary documentation and what are the necessary prerequisites for an exemption. So those are main issues that will be in play depending upon what mandates we're talking about. Next question that we're always thinking about, and now we need to keep juggling in our minds, is what's the effective date of the mandate? And in particular, we'll hear in a few minutes about the new federal rules that have effective dates and then vaccination requirement dates. And so there's often 2 or 3 different dates that you need to keep in mind as you proceed implementing those requirements. Next question that's common to all of these is what are the consequences for noncompliance? Are we talking about discipline? Are we talking about leave? Is there a work from home option? Might we have separation from employment at the end of the day? Those are all questions that we're going to need to answer in terms of, the what if. when at the end of the day, if the mandate is not met, the requirements are not met, and there's no applicable exemption, what do you do? Okay. Then we've also got to think about legal actions. What actions might be out there. We've seen on the mandate side, we've seen injunctions, we've seen grievances, unfair labor practice charges. So there are potentially all manner of potential challenges that are out there that relate to different aspects of what's been implemented. And then finally, you've got some additional things to think about, which is, pay for vaccination time, who pays for the side effects, if there is side effects in terms of missing time, and of course, what are your pay obligations to give sick leave to people who get COVID, especially now that a vaccine is available if people have decided not to get vaccines. So all those things are a matter of statute. They're pretty much going to be governed in New York by the New York law requirements, but those are some things I think we need to think about as well. So those are just some of my sort of opening thoughts. We wanted to spend some time today kind of cataloging the mandates for you. We're going to spend a little bit of time talking about the New York City Public Accommodations mandate, the New York State Healthcare Workers mandate, and then we'll talk primarily about the federal contractors, the OSHA, the CMS mandates. And then, of course, we're going to finish up today with a little update from Albany as well. So with that in mind, let's just go back over the healthcare provider mandate. People will remember this somewhat tortured history, and we've been through this. The ultimate thing that happened here was that New York State put a vaccine mandate in place that did not have a religious exemption. And there was litigation over that. And there was ultimately an injunction was issued. And that injunction basically said that the lack of a religious exemption was problematic in the emergency regulations, that it potentially singled people out on a religious basis. And so that injunction was put in place by the Northern District of New York. Ultimately, this matter went up on appeal to the Second Circuit Court of Appeals. And what we saw recently, it was October 30th, issued frankly overnight, I think Friday to Saturday morning. The Second Circuit vacated that injunction and allowed the regulation to go into place fully. Now, the regulation had been in place previously to this extent. It did require vaccination as of the effective dates, and it did provide for a medical exemption. But what was not in there was a religious exemption. That part had been enjoined, and then the Second Circuit removed that injunction, which now puts the entire regulation in effect. So I guess the question becomes, as we move forward, what a healthcare employer is going to do as a result of the now effective New York regulation. Couple of comments on that. One is that it will be, an application has been made to the Supreme Court. It's possible that the Supreme Court might take that issue up on an emergency basis. If not, the regulation would remain in effect, and it could go back up through the court system. Remember, we're talking about an injunction here. That's expedited relief. But there also is the potential for the court to hear, the case and decide later on whether or not it's beyond the scope of the authority of the New York State Department of Health. So stay tuned on that. The other thing that we will have to wait and see is what the Department of Health says in terms of trying to reconcile its regulation with the federal regulations that have just come out from the Center for Medicare and Medicaid reimbursement, and also the whether or not the Department of Health will comment at all on feathering this out and when to give employers a little bit of guidance on when their expectation would be that religious exemptions could no longer be processed to allow in-person work. One more thing before we move on to the New York City executive order, and that is that there is still the issue of processing religious accommodations, even if the regulation is in effect, and workers who are patient-facing and interacting with patient-facing workers cannot work in person. And that would be to evaluate the question about whether or not there's leave, working from home, or some other accommodation that could possibly be available for somebody. So I think that our advice has been that employers should consider the reasonable accommodations, but with the New York regulation being in effect, it's likely going to be an undue hardship to allow in-person work. And so I think that's where that stands. So one of the interesting questions, and we'll talk about it with our panelists here, is how that particular rule plays out with the federal rules that we'll be talking about in just a few minutes. Before we move on to that, though, I do want to talk just briefly about the New York City executive order. And as I indicated at the beginning, you do need to be concerned about local rules as well. New York City has a couple of these, and the key to New York City, we've talked a little bit about this in the past, but it's a vaccine mandate basically for indoor venues, restaurants, indoor entertainment, fitness centers, things of that nature. And there is no test out. So this is what at the beginning I called, a vaccine mandate, in the sense that you can't just test out of it. There are provisions for medical and religious accommodations. And there are some exceptions for certain de minimis activities, such as deliveries or, people who briefly go into a venue to use the restroom, things of that nature. So what we end up here with under this particular executive order is that people cannot go into these venues unless they've been vaccinated or unless they have a religious exemption. So true vaccine mandate there. To this point, it has withstood judicial scrutiny. And the New York City mayor-elect has said that he will keep this mandate after he goes into office. So at least for now, we're expecting this to remain in effect. For those of you who are sports fans, there's been quite a bit of commentary about Kyrie Irving, and a member of the Brooklyn Nets who is not vaccinated and is not currently allowed to play in New York City as a result of this executive order, and that apparently will remain in effect after after the new mayor goes into office as well. It's just an example in the popular media about what the impact of this is, including not being able to access these venues while the executive order is in effect. So keep your eye on the local requirements as well as the state requirements. But I really want to shift now to the federal requirements. To kick us off today, I think we want to talk about the OSHA's emergency temporary standard. We've got Neela Sikander with us today, and Neela authored a blog post that I know a number of you have seen, very informative, but she's going to share her thoughts with us on the ETS from OSHA and where we are with that.
Good afternoon, everyone. Let's start with our first slide. So November 4th, OSHA announces that an emergency temporary standard will be published in the Federal Register. November 5th, the ETS becomes published and effective. There are particular deadlines that you need to be aware of, and we're going to talk about those deadlines and what you need to kind of comply with. Most provisions are effective December 5th, except for testing requirements. I'll provide some detail on that later, but that would be January 4th, 2021. OSHA cited a grave danger posed by the coronavirus in order to come up with this emergency temporary standard, or ETS. The ETS is also a proposed rule, and public comment is invited. The deadline for that is by December 6th, 2021. So on November 4th, what happened? So in a nutshell, next slide, please. 84 million workers were impacted. In a nutshell, the emergency temporary standard requires employers with 100 or more employees to mandate vaccination for all their employees, or vax or test and mask. So those are two options that they've kind of presented. That's the employer's choice. There are also requirements regarding paid time per vaccination dose and for recovery from vaccination side effects. So next slide, please. On November 4th, I started preparing a to-do list, and I figured I'd share this in the form of a to-do list for you. If you want more additional information, here's a link to the Labor and Employment Law blog post that was posted on November 4th regarding the ETS. Next slide, please. So first question, does this apply to us? Well, employers with 100 or more employees kind of does, yes. There are exceptions. So if you're an employer covered by the federal contractor mandate, or an employer covered by OSHA's healthcare emergency temporary standard, then the OSHA's ETS would not apply to you. OSHA states that it is all of these ETSs and mandates are kind of consistent with each other. Next slide, please. So next, how do you count to 100? So here's how we do this. You count at the corporate level. So it's not single site based, but you need to combine all employees at all locations. So OSHA contemplates a single corporate entity. So I've got a lot of questions on, well, does this include subsidiaries that my parent company wholly owns? Chances are yes. OSHA does have a single employer doctrine that you would need to look at, but chances are your subsidiaries that you wholly own would be covered. You do need to count part-time employees, count temporary or seasonal employees, but do not count temporary employees that are employed via a staffing agency. Do not count properly classified independent contractors. Count employees working from home. And then if you're in your business is in like a multi-employer work site, kind of like a construction site, you only need to count your own employees, not the total number of workers at the site. You do need to count employees who are minors, yes, even if they need to get their parents' consent for vaccination or testing. And when do you count? You count as of November 5th, 2021. If you're at November 5th, say you were at 75 employees, and then you hire 27 additional employees, and that you meet the 100 employee threshold, then the ETS applies to you at that point. Once you are at the 100 employee threshold, you are covered, even if you drop below that number. Next slide, please. So does it apply to all your employees? Yes, except for employees who do not report to a workplace where other individuals such as coworkers or customers are present, employees while they're working from home, employees who work exclusively outdoors. All of these are exceptions to employees who are not covered under the ETS. Now, we want you to kind of approach the employees who work exclusively outdoors exception, proceed with caution there, because the employee must work outdoors on all days. if they routinely occupy vehicles or with other employees, this is considered indoor time. So they can't routinely occupy vehicles with other employees. If they use the bathroom occasionally, that's fine. To, like, say the company, common bathrooms where other co-workers are present occasionally, that's fine. But time spent indoors will be added up cumulatively. So you want to kind of be aware of that. I know I got a question if field representatives are covered. In this instance, field reps that, come in and out of work, grab paperwork, use a computer, the chances are they would be covered under the ETS and would not fall under the working exclusively outdoors exception. Just because they may not be covered by the ETS does not mean that you exclude them from the total count of employees. So you need to include these employees in your total count of employees to meet the 100 employee threshold. Next slide, please. So to vax or test, that's the question, right? So if you choose to vaccinate all your employees, you're choosing to go that route. It's a mandatory COVID-19 vaccination policy. You must require vaccination of all employees, except for those with certain medical and medical conditions, or who are requesting a reasonable accommodation subject to a sincerely held religious belief. You want to be cognizant of New York labor law and human rights law in terms of reasonable accommodations in this regard. If you do provide these three categories of employees an exemption from your mandatory vaccination policy, you must test them weekly for COVID-19 and require that they wear a face covering as per the ETS's requirements. You could also choose to say, I'm just gonna not mandate vaccinations. I'm gonna vax. I'm gonna, provide them with an opportunity and support employees to get vaccinated. But in the alternative, I would allow them, you as an employer would allow employees to test and mask. So each employee who's not fully vaccinated, you can require that they be tested every 7 days. If they work remotely, and are planning to come back to work, you must make sure that they are tested within 7 days before returning to work, and you need to receive those results as well. And you need to require masking. A question that I've gotten is, well, I want to mandate vaccination for one group of employees, and then for a subset of employees, I need to vax. I want to offer the other option. And yes, you can do that. You can offer the OSHA talks about mixed vaccination policies, where you apply one policy for one subset and the other another policy for another subset of employees. I advise that you talk to your legal counsel when you kind of contemplate those complex type of policies. Next slide, please.
So Neela, let me just jump in here real quick, because I want to make sure that our group here gets the different nuances. So I mentioned at the beginning sort of the difference between a vaccination, mandatory vaccination, or testing and vaccination. But this OSHA ETS is actually a hybrid, in that a third option, in that it offers both options within the same ETS. Whereas a lot of these rules that we've seen, either employer-based or regulatory-based, go one way or the other. Say it's either a mandatory vaccination unless there's a required accommodations, or it's a vax or test. But this is either or within the same ETS.
Right, as long as you have a well-defined specific subset of employees, they've kind of anticipated that and considered that option as well.
And the other thing that I want to summarize some of the questions, and I'm not really going to ask you to answer them, but I'm going to offer a question or an observation in the form of a question. But, this reminds me very much of back in the old days when we were trying to figure out how to manage different counting, different coverage thresholds for the ADA and the FMLA. And then you also had, the workers' compensation law, and everyone was trying to figure out what their obligations were and who was covered and, things of that nature. And I guess, I sort of feel like we're in the same space here again. And that is that, everyone's unique circumstances are going to require some sort of application of this rule. How do we count for coverage purposes? And then to whom do the rules apply once we're a covered employer, and, all those sorts of things. So I love your checklist approach, because it seems to me that that's kind of the way to, approach all these things, is saying, threshold question, am I covered by this particular rule, this particular mandate? And then you work your way down through the questions. And to the extent there are overlapping obligations, you'd want to do that for other rules as well, and then try and figure out how they play with each other or don't play with each other. So I guess that's more of an observation, but I mean, it just seems to me that the questions that folks are asking are all going to be very fact-specific inquiries, under their workplace, and the recommendation is going to be to work through it.
Absolutely. I mean, there are these nuances that you kind of have to explore that are so specific to you as an employer. So having said that, OSHA has said that, they've prepared templates for a mandatory vaccination policy, as well as templates for vaccination or testing and face covering policies. So, I mean, when in doubt, use the policy, but know that I've actually looked at a couple of these policies that employers have been putting together, and I found that you kind of need to tweak it as you go along. There are these like spaces where you have to kind of fill in what your own kind of take on things are. So take a look at those templates. Those are very useful in terms of navigating what a written policy requires. You do have to provide a written policy. That's important, especially if you're picking option, well, they're important for both, but the only way you can have that alternate test and test or vax kind of policy is if you have it in writing. So you need to make sure that you do that. And we need to kind of follow some of the attributes of those templates that they provided. Next slide, please. So one of the things that employers also have been asking about is, oh my gosh, this is kind of a huge burden in terms of paperwork. Like, what do I need to do? And yes, you do need to determine and track vaccination status of all your employees. You need to maintain a roster of employee vaccination status. OSHA states that it needs to be for the duration of the ETS, which it anticipates being 6 months, but let's talk about that later. But I mean, one of the things is that confidential medical records, they need to kind of be part of, conform with your retention policies as well internally. So what is acceptable documentation for proof of vaccine? I won't read the entire list of it, but those are kind of what OSHA has prescribed. Interestingly, next slide, please. If an employee, OSHA talks about this interesting situation where employees may have lost their proof of vaccination, or they're not able to produce that proof. So the employees are allowed to attest to their vaccination status in that kind of instance. You do need to include language that I've prescribed here and that have been prescribed by the ETS. One of the other pieces is, and we'll talk about this when it comes to notification, there's like an honor system here. So employers can't necessarily invite or facilitate fraud, but it does not require you to police, monitor, or detect fraud. and that's an interesting set of facts, and there's a fact sheet associated with it that I'll share in another slide. Next slide, please. So you do have to provide paid time off. For a vaccination, you do have to provide 4 hours of paid time to receive each primary vaccination dose. This is separate from regular leave benefits. Questions that I've gotten is, well, can I provide the 4 hours and require them to use like sick leave? No, you cannot. And if you're in New York, you already know the regulations that are pertinent to providing time off for vaccination. If the employer offers time during the workday and the employee does not accept and gets vaccinated on their own time or the weekend, if they're not working the weekends, employer does not have to pay the vaccination time. And the ETS also asks that you provide reasonable time and paid sick leave for employees to recover from any side effects experienced following each vaccination dose. So what's reasonable? OSHA doesn't necessarily define this, but it has said, well, if you provide at least 2 days of paid sick leave, we're not going to, enforce this. So I would say at least 2 days of paid sick leave would be a good rule of thumb. Now, interestingly, you can require employees to use sick leave. So if you track sick leave and vacation time separately, and it is available in the employee's leave balance, you may allow employees to use only the sick leave benefits. However, if the employee does not have any accrued sick time, you as an employer cannot allow them to accrue negative sick leave or borrow against a future paid sick leave balance to recover from vaccination side effects. In that event, you need to provide them with paid sick leave. Next slide, please. So if employees fall within those exemptions and categories that we talked about under your mandated vaccination policy, or you choose to test, test or test and mask policy, you do have to test the unvaccinated. So you have to do that every 7 days. You want to make sure that PCR tests are acceptable, rapid over-the-counter tests are acceptable. An employee can self-administer the test and self-read it, but they cannot both self-administer and self-read it. So employers have been asking questions like, well, can I just buy the test and administer this for all my employees? If you do need to get a certain type of waiver. So you want to talk to us about like how you go about getting that waiver. The other alternative is to have an employee self-administer the test, and then you observe that self-administration, which works as well. So if the employee is in the vaccination process, you must test them until fully vaccinated, unless the employee gets a last dose on or before January 4th. Next slide, please. You have to require employees to promptly provide notice of a positive COVID-19 test or a COVID-19 diagnosis and remove these employees from the workplace. The ETS prescribes certain return to work criteria that I advise that you look through. Go ahead and look at like what they deem as okay. It's usually a green light from a healthcare provider or a negative test and so on and so forth. So you want to go and look at some of those requirements. Next slide, please. You have to provide notice to employees. One of them is the key things to know about COVID-19 vaccinations. But there are also 2 other fact sheets that I recommend that you provide employees. OSHA wants you to make sure that employees can't be retaliated against. Employees know that they can't be retaliated against for and then also wants you to notify employees that there are criminal penalties for false statements. That goes back to that whole honor system type of thing that OSHA contemplates. Take a look at those fact sheets and provide those to your employees along with your written policy. Next slide, please. There is documentation involved apart from all of the record retention that we talked about before. By the end of the next business day, after a request by an employee or employee's representative, you as an employer must make available the aggregate number of fully vaccinated employees at a workplace, along with the total number of employees at that workplace. And this goes back to your roster. Your roster needs to be current. You need to be on top of this information. If OSHA asks for a written policy and number of vaccinated employees, you must produce this within 4 hours of the request. So it's kind of like, this is what I've been hearing is that it's a lot of kind of paperwork and tracking and record keeping that you do have to kind of be on top of. Next slide, please. You must report work-related COVID-19 fatalities to OSHA within 8 hours of learning about them, and report work-related COVID-19 inpatient hospitalizations within 24 hours of you learning about that hospitalization. Next slide, please. Other considerations. There are some things around face coverings that you want to take a look at. Exceptions that they prescribe. So when can an employee take off their face covering or mask? A limited time while they're eating or drinking, or when they're alone in a room with a closed door. And then if you do, at the end of the day, there are also penalties associated with not complying with the OSHA's newest rule. Next slide, please. So what's next? We've all heard on November 5th, the Fifth Circuit temporarily stayed the ETS pending further action by the court. They stated that there was grave statutory and constitutional issues with the mandate. And the Department of Justice says, they wrote a letter to the court, but what I gathered from it is, take a seat. We need a lottery to pick the circuit that decides the fate of this ETS. This is premature. So I kid you not, there is a lottery because there are so many lawsuits. There's actually a lottery system, a multi-circuit type of lottery system where they basically pick a circuit, from the constitutions that have provided, have submitted lawsuits. And then that court goes through some of the pre-trial proceedings. So the Department of Justice says, well, we kind of need this circuit to decide that. This is premature. We're going to have to wait and see what the Fifth Circuit decides. I would say wait a couple of days, wait to see if the OSHA rule is preliminarily enjoined. And if so, is it nationwide? So one of the things is you kind of don't know what to do. I would say go through this to-do list, go through and start prepping for this, because timelines and court decisions may change. So you need to plan accordingly to meet the deadline. You don't want to wake up on December 5th and realize that you have a whole bunch of things that you need to kind of get through. You want to kind of address that and plan accordingly right now. And then we'll wait and see, and we'll keep you posted if things change down the line. So that's it for kind of my spiel and my to-do list. My to-do list is much longer than this, but I figured I'd kind of summarize this for you.
Neela, thank you so much. A lot of information there. Let me pick up on a couple of things. First of all, Neela, if you could send out some of those links in the Q&A. People have been clamoring for them, and we will be providing the PowerPoint. The PowerPoint will have hot links in it. It'll go out probably tomorrow sometime, as it does. So it'll be available to people, and they will be able to click in there and get to the links. But we'll also try and send a few of those links out now in our remaining time. The other thing is that I think your last piece of advice, Neil, is excellent. And that is, we don't know what's going to happen It probably makes sense to do some planning and get prepared. How much of that you want to do and how much of that you want to defer, I suppose depends on, how busy you are and what you think the likely outcome of the court proceedings would be. But I think it's our recommendation that people, get their heads around what the to-do list will be at least, so that, they have enough time to the extent that the rule is going to go forward. So with that, we're going to turn to the other side of the coin with Stephanie Fedorka. Stephanie's going to talk a little bit about the federal contractor requirements and the CMS rule. And again, people have been saying in the chat, asking these questions about, which rules apply to me. And I think our recommendation is you have to work your way through which rules apply to you, because they are overlapping in many regards. So Steph, take it away.
Thanks, Pete. I'm going to throw a lot of information at you all, so I appreciate your patience. You will have access to the slides, and I know that your time is valuable. So I'm going to go through these basic requirements, the key highlights of two of the federal mandates. One is the federal contractors mandate, and the other one is the CMS, the Centers for Medicare and Medicaid Services. So first, starting off with the federal contractors mandate, on September 9th, President Biden signed Executive Order 14042 called Ensuring Adequate COVID Safety Protocols for Federal Contractors. Essentially, what it did is it requires this Safer Federal Workforce Task Force to issue guidance, and it requires federal agencies that contract with specific covered contracts that we'll get into a little bit in a couple of slides, to incorporate a clause into covered contracts that requires those contractors to abide by this Safer Federal Workforce Task Force guidance. So ultimately, it boils down to three requirements set forth in the guidance. One is that covered federal contractors must ensure that covered contractor employees are vaccinated for COVID-19, except in limited circumstances where an employee is legally entitled to an accommodation. Two is requires federal contractors to comply with certain safety guidance in the guidance with respect to individuals that are coming into that workplace, that covered contractor workplace. It's going to include things like wearing masks and physical distancing. And three, it requires the federal contractor to designate an individual to coordinate those COVID-19 workplace safety efforts at that covered contractor workplace. There's a bit of a phase in here. The executive order directs the federal agencies to incorporate the new clause as follows: in new contracts awarded on or after November 14th, in new solicitations issued between October 15th and November 14th, in extensions or renewals of existing contracts or awards that were awarded on or after October 15th, and or in options on existing contracts and orders exercised on or after October 15th. So this is what the directive is. However, I will bring this up in a couple slides as well. There's discretion that's awarded to these federal contracting agencies to incorporate this new clause even before they have to, as set forth in this schedule in the order. As to coverage, this new requirement applies to any new contract or new contract-like instrument, new solicitation for a contract or contract-like instrument, extension or renewal of an existing contract or contract-like instrument, and exercise of an option on an existing contract or contract-like instrument if it falls into one of these four categories. It's a procurement contract or contract-like instrument for services, construction or leasehold interest in real property, a contract or contract-like instrument covered by the Service Contract Act, a contract or contract-like instrument for concessions, or a contract or contract-like instrument entered into with the federal government in connection with federal property or lands and related to offering services for federal employees, their dependents, or the general public. Importantly, I said contract or contract-like instrument several times. That has a very broad definition. It follows the U.S. Department of Labor's proposed rule with respect to increasing the minimum wage for federal contractors. But I think this is one of those pieces where if you're not sure whether or not you're covered, to contact your favorite bond attorney, your labor counsel, whoever it may be, because it's not necessarily a uniform application of what a federal contractor is under various different laws. So just because you're a federal contractor under other regulations may not necessarily be determinative as to whether or not you're going to be tagged by this federal contractor mandate. So the definition is broad. It includes any agreement between two or more parties creating obligations that are enforceable or otherwise recognized by law. It includes things and examples like lease agreements, procurement actions, provider agreements, service agreements, notices of awards, job orders, purchase orders, etc. So it's very broad. Like I said, it's very broad and sweeping, and the executive order and guidance provides federal agencies and contractors with discretion to incorporate the new clause into contracts that are not directly covered by the order. So even if they're not directly covered, the order and the guidance encourages agencies to incorporate this clause into any contract or contract-like instrument that isn't directly or explicitly covered. Importantly, the executive order clearly states that it does not apply to things like grants, contract-like instruments, or contracts with Indian tribes under the Indian Self-Determination and Education Assistance Act, contracts or subcontracts whose value is equal to or less than the simplified acquisition threshold, which is currently $250,000. It does not apply to employees who perform work outside of the United States or its outlying areas, or subcontracts solely for the provision of products. But again, noting that there is discretion that an agency can exercise to incorporate the clause, even if it doesn't apply. So keeping tabs on that and having, if you have contract professionals or you have individuals who are reviewing contracts, to be on the, keep a lookout for the incorporation of this new clause. With respect to the vaccine mandate, which will be the focus of this discussion today, covered contractors must ensure that all covered contractor employees are fully vaccinated for COVID-19. It defines covered contractor employees as any full-time or part-time employee of a covered contractor working on or in connection with a covered contract or working at a covered contractor workplace. So that also includes employees of covered contractors who are not themselves working on or in connection with a covered contract. And they provide some examples of what in connection with a contract means. That's individuals like human resources or legal, or those who are working in connection with performance of the contract. So again, very broad, very sweeping as to who will be covered in your workplace. So by when? Originally, it was December 8th was that magic deadline for full vaccination. That has gotten kicked to January 4th so that it is consistent with all of the other vaccine mandate deadlines. So that's, I want to say unofficially official because it has been published or talked about, but there's no official change in the order or in the guidance as of yet that I checked this morning. But for all intents and purposes, we're pretty confident that this vaccine mandate for federal contractors is also getting kicked to January 4th. After that date, all covered contractor employees must be fully vaccinated by the first day of the period of performance on a newly awarded contract, and by the first day of performance on an exercise option or extension. So that, you know, if any contracts have been awarded after that date, then this provision will kick in and you have to be fully vaccinated and compliant by that first day of the period of performance. Note that there's no testing opt-out here. Reasonable accommodations can and should be evaluated for disability or medical contraindication and sincerely held religious beliefs. Note that periodic testing could be a type of accommodation, but there's no voluntary testing out option like there is with the OSHA ETS. Contractors must flow down the clause in subcontracts. So even if you're not a direct federal contractor, you may be a subcontractor. So again, keeping an eye out for any communications or incorporation of this new clause into a subcontract that you may be a party to. Contractors must comply with applicable safety protocols if they're performing work at a federal workplace as well. So if you have employees who are going to a physical federal workplace, there may be additional obligations and additional safety protocols that they will be expected to comply with. Recent guidance from the White House have issued statements seeming to indicate that there's some flexibility for contractors with respect to complying with this mandate in good faith. It's not a cliff. And that to me doesn't mean that the January 4th deadline isn't real. I think as long as you are making a good faith effort to comply, you don't have to terminate individuals who haven't complied with that mandate by that date. There is a little bit of flexibility. I think there is, in the guidance, there are some recommendations of how to work with individuals who are not compliant by that deadline. By the same token, if you have individuals who request a reasonable accommodation and perhaps it isn't fully evaluated or approved by that time, or perhaps it's denied, you have some flexibility in making sure that you're compliant and you don't have to take rash action, I guess, is the best way to put it. So that is my very quick federal contractor mandate synopsis. Any questions, Pete, before we jump into really quick the CMS interim final rule?
Nope, go right ahead. There's a lot of
Awesome.
questions, but I think we're answering them, and we'll do the grab bag next week. We had a lot of material to cover, so we'll circle back on these. So please proceed.
Great. So for the CMS rule, this is an interim final rule. It's an emergency regulation. Again, on September 9th, the Biden-Harris administration announced that it was going to require COVID vaccination for all staff within Medicare and Medicaid certified facilities. So on November 5th, that interim final rule was published in the Federal Register. So what facilities or which facilities are covered? Medicare and Medicaid certified provider and supplier types, which are listed here. Those are your ambulatory surgery centers, community mental health centers, et cetera, et cetera. Long-term care facilities, again, those which are under the governance or under the regulations of CMS. What staff are covered with respect to this vaccination requirement? Staff working at a facility that participates in the Medicare and Medicaid programs, regardless of clinical responsibility or patient contact. It includes in the rules and in each section, what it does is it modifies each particular section and regulation with respect to each of those enumerated facilities, the types of individuals that are going to be covered. But ultimately, it boils down to facility employees, licensed practitioners, students and trainees as well that you may have in your facility, volunteers, or other individuals who provide care, treatment, or other services for the facility and or to its patients under contract or another arrangement. Ultimately, all staff who interact with other staff, patients, residents, clients, PACE program participants, et cetera, in any location beyond formal clinical settings must be vaccinated. It does not apply to individuals who are working 100% remotely. So that is clear that that's one exception, if you will, to this vaccination requirement, but they have to be 100% telecommuting, either providing telehealth or telemedicine services outside of the facility and who have absolutely no direct contact with patients or other staff. So individuals who primarily work remotely, that they're still going to be required to be vaccinated. Same thing, staff who provide support services that are performed exclusively outside of that facility where those patient care services are being provided and who do not have any direct contact with patients or other staff that have to be vaccinated under that list. Those individuals do not need to be vaccinated either. Other exceptions to this rule, religious non-medical healthcare institutions, organ procurement organizations, and portable x-ray suppliers are not directly covered, but the rule and guidance does note that they may be covered by a relationship with other covered facilities under that requirement that the covered facility has to ensure that any individual who's coming into the facility that provides services, either by contract or other arrangement, is vaccinated. It does not directly apply to physicians' offices or other healthcare entities that are not regulated by CMS, but there is, the guidance does make it clear that physicians with admitting privileges, similar to what I just mentioned, are going to be covered by virtue of their relationship with the hospital, who is going to require any individuals who are coming into the facility to be vaccinated to provide services. So I tried to boil down, and again, I'm not going to read every single thing off this list, but ultimately what is required aside from that vaccination requirement. So it requires covered facilities to provide and to prepare procedures and processes and policies to cover these specific issues. So one is establishing a process to fulfill that staff vaccination requirement. It's a 2-phased rollout. By December 5th, all covered individuals must have received at least their first vaccine, and you have to have your policies and procedures in place and established. It does provide a little bit of flexibility here in the sense that the guidance states that staff who have received at least their first vaccine before providing, they have to receive at least their first vaccine before providing any patient care. And again, this is more so to phase 2. They have to be fully vaccinated by January 4th. If staff have completed the primary series, so they received their 2 shots or that 1 shot in the J&J, they're deemed to have met the requirement, even if that 14-day waiting period has not fully or completely lapsed. You have to establish processes for tracking and securely documenting COVID-19 vaccination status of all covered staff, including any boosters that are going to be recommended by the CDC. Establishing processes for collecting and evaluating requests for reasonable accommodation or exemption to the vaccine requirement in alignment with federal law. They do provide that you can consider medical delay for certain recognized reasons and sincerely held religious beliefs. You must include a process for tracking and securing information provided by those requesting the exemption. So keeping all of that documentation and maintaining it as well. For medical contraindications and delay, it also requires a very detailed and specific list of what must be included in the request and documentation. For example, it must be signed by a physician, and that physician cannot sign their own medical exemption request. But there are very specific details as to what needs to be included and recorded in that request in the regulations as well. You must establish a process for ensuring the implementation of additional precautions intended to mitigate the transmission and spread of COVID-19 for those staff who are not fully vaccinated, those that have a granted exemption, and then also have contingency plans for those who are not fully vaccinated for COVID-19. So again, I think all of this goes to that final December 5th, you have to have these policies and procedures established and prepared. Again, a great opportunity. There is some flexibility as to what those will exactly look like. There aren't a ton of details, but working with legal counsel to help you prepare any written policies or procedures, or if you have questions. This is meant to preempt any state law that's to the contrary. So it specifically provides in the guidance those state laws that prohibit vaccine mandates. The CMS interim final rule preempts that. And it's meant to be complementary to the OSHA healthcare ETS, the OSHA ETS, or the federal contractor guidance. What I should have also noted before was that the federal contractor under the OSHA ETS that Neela just spoke about, the guidance provides that if you're subject to the federal contractor guidance, that will apply and not the OSHA 100 plus ETS rule. So that's an interesting piece that I forgot to mention at the end of my prior segment, but a lot of information.
Yes, Steph, a lot of information. Thank you for that. One thing that we will keep our eye on and probably discuss further, well, all of this stuff, and we could probably do a complete webinar next week on just your questions. But the preemption issue needs to be analyzed, and we have to figure out how these things work with one another or don't work exactly perfectly together. Let's move on. I want to do just a quick update from Albany. Katie has been texting me in the chat saying she doesn't have a lot, but just a few quick thoughts. So wanted to get this in. Katie, take it away.
All right, I'll be as quick as I can be. Let's start where we always start. Cases have been increasing in New York. This is not great news. We're looking at this upward trajectory that we've seen over the past 14 days. Cases, the average increase has been 11%. This is driven primarily in counties where vaccination rates are extremely low. that has made things difficult for, health officials to work with. All of our numbers with vaccinations statewide have gone up, and there has not been any tracking that's been released yet for tracking how many children between 5 and 11 have been vaccinated. But this graph is a really good correlation between, where you're looking at fully vaccinated people and the places in New York State that currently have the highest rates of spread. Allegheny County has the lowest rate of vaccination in the state, and it also has the highest rate of transmission in the state. So keep your eyes out for what's happening there. Finally, looking at the federal infrastructure bill, big week that we had federally, people. More than just OSHA, we had this enormous infrastructure bill pass the House. It passed the Senate over the summer. What's in it? A ton of stuff. There's a lot of money in there to go to a lot of different places. Lots of money for broadband. There is a $30 monthly voucher now that low-income Americans can receive to supplement their broadband needs. That is the first real time that we've invested in infrastructure as broadband in this country. Also, lots of money for climate programs. New York City is going to be getting a ton of money for revitalizing the MTA. And Amtrak will be getting a lot of money too. So if you are somebody who, like me, enjoys going up and down the Hudson River Valley, that's great news. So that's it, Pete. You said 2
Katie,
minutes,
thanks.
I gave it.
You were quick. You were as promised. So here's our information if you need to contact us. I think we're likely just going to unpack this further. We also did a standalone pop-up today on the OSHA ETS. That'll be available as well to our clients on the website. So thanks everyone for participating today. Please stay safe, and we'll talk to you next week.